Okay, 11 o'clock. Welcome back. We're now getting into our standard bread and butter for spring conference. We're going to do our criminal legislative update. We've got Will Carlson from the Salt Lake DA's office, Marlesse Jones works at UPC, and Tyson Skeen at UPC. You all know them, so I don't have a bio like I do some of our other presenters. So I'll let them introduce themselves. I'll just tell you that they're awesome, and we'll go from there. And so we're going to go until 12:30, and then we'll take lunch. So take it away, guys.
Thank you, Rob. Appreciate that. In a conference where we're talking about bias, I'll admit my own bias and say I agree with Bob that we are awesome. And if we do anything today to change your opinion of that, just go back to the previous statement that we're awesome. A couple things before we get started. Some considerations that we want you to be thinking about here. We're going to go through these bills. We're going to talk about them in as much detail as we reasonably can under these circumstances. But the reality is there's no substitution for actually reading the law, right? Law School 101, first day in law school, what do they say? You get a question, well, what does the law say, right? So it's important for you to actually read the law. Unless otherwise stated, all these bills go into effect next week. May 5th is the implementation date, general implementation date for bills. Some are maybe already in effect. Some may have delayed implementation dates. The summaries are in the materials. So the legislative summaries for everything are in the materials. You're going to see at the top of almost every single slide a number in the top left corner, and that is the page number for the summaries. We probably aren't going to point that out every time as we go through. That's there for you. You can see it and do that. So, yeah, if you have questions, we're happy to answer them as we go along. As others have said, we're going to get right in this.
Okay, and just one side note that we didn't have on the slides. I know you were all hoping that Will would again sing for us this year, but he is in talks with the record label, so he's not able to do that. We'll keep you posted. We're going to talk about domestic violence amendments. I think this is a good slide to start with. Justice is coming. We all know that when the legislature convenes and bills start, surfacing and discussions happen, that, we end up with some good and we end up with some not so good, and sometimes we end up with some bad. So, but this bill has got some good points in it. It does basically three things. So with regards to domestic violence enhancement, this does not include juvenile adjudication. So they've separated that out to make sure that that's clear. It does not include juvenile court adjudication. This bill also creates a definition. It creates the definition for offense against the person. And what that means is commit or attempt to commit an offense under 76.5 parts 1, 2, 3, 4, and 7 by one cohabitant against another. So be aware of that new definition. Then this bill also, this is the justice part of it, because anyone that has had domestic violence cases, you have those perpetrators that are repeat offenders, and some of them are offending faster than we can get them through the process, and it's incredibly frustrating. So this bill includes an enhancement to a third-degree felony if the suspect has committed or is convicted of a prior Class A misdemeanor domestic violence offense, or now also that includes if they've committed or are convicted of 2 or more Class B misdemeanor domestic violence offenses. Now remember the windows of enhancement, it's 10 years other than criminal mischief, which is 5, but we will have that new enhancement opportunity based on commission of the offense as well as multiple convictions at the Class B level that can get us to the third-degree felony for those perpetrators that need to be there.
House Bill 260, criminal justice modifications. Well, the title says it all. Criminal justice is modifying. But this is one of the bills that is not taking effect next week. So the good news is, even though restitution, as you know it, will fundamentally change forever, that will not happen until July 1st. So you have a few months to get ready. How, you may ask, will restitution change? In almost every way imaginable. Under the current statute, there are specific definitions of restitution that are case-specific definitions. That is gone. Under the current law, there is complete restitution and court-ordered restitution. That is gone. Under the current law, there's an implication that APMP actually does something when it comes to restitution. That is gone. The work is going to be front-loaded. Law enforcement, prosecutors, you have to do a lot more work when it comes to identifying restitution. For example, under this bill or upcoming law, a plea and abeyance agreement or a diversion agreement cannot be accepted by the court unless either A, restitution is explicitly identified, or B, there is a statement from the prosecutor that says they have contacted every victim in the case, including the Office for Victims of Crime, and there is no restitution. Every plea and abeyance agreement, every diversion agreement. At sentencing, you have to provide the restitution amount or the estimated restitution amount. If you don't have it, and if the judge has not included that as part of sentencing, the judge has to schedule a post-sentencing restitution hearing. The idea of having up to a year until or after sentencing to determine restitution, that is fundamentally gone. There is an outer limit, and there is an opportunity to modify restitution. So if you have a case that resolves with, say, a serious bodily injury where a defendant has caused so much harm to a victim that they are receiving ongoing medical treatment, there is an opportunity to modify the restitution order after sentencing. But restitution, as we have known it, is going to fundamentally change. State debt collection is, and Cliff and I disagree a little bit about this. Cliff is our specialist in restitution at the DA's office, one of the smartest gentlemen I know. But we do disagree on this, and that is that state debt, the state debt is going to largely be shoved out of restitution during the criminal case itself. So even though the statute says there will no longer be complete restitution and court-ordered restitution, what the statute says is you have to identify what the restitution amount is. That's the loss to the victim. And that's the restitution amount. But then the judge has to create a payment plan for the defendant. And the payment plan is going to look a lot like what court-ordered restitution used to be. For example, you could have a case where a defendant is ordered to pay restitution in the amount of $80,000 over their 3 years of probation, and then they are ordered to pay $100 a month. And I'm not a math major, but $100 a month for 3 years of probation will not result in full restitution being repaid to the victim. So there is still the ability of the defendant to pay that's taken into consideration, but state debt collection is going to be kept out of those cases when someone doesn't pay. Right now, if you have any case where a defendant has not been paying, there are some judges that are very enthusiastic at kicking that to state debt, saying we're not going to worry about that anymore. It's going to state debt. They can worry about this. And if it's a case where the accounts receivable does not include restitution, they can still do that. But in those cases where restitution is part of the case and the defendant has become delinquent, the court has to keep that case, keep that restitution until the criminal case is done. At the time that the sentence is completed, whether that's probation or serving the full sentence, the remaining amount can be converted or will be sent over to state debt collection. Some judges under the statute will have the authority to keep it. Most judges will not. But the idea is that state debt will come into play after the criminal case. But during the criminal case, and while it's probation or parole is pending, the court is the way that the individuals are going to pay. And if I haven't said it before, APMP is going to have nothing to do with paying restitution. All right? So other than everything changing July 1st, that's all that's happening with criminal justice modification.
SB 179 DUI probation amendments is a bill that actually was really well intentioned, I think, and did some really good things. So we all know that APMP doesn't supervise Class B misdemeanors and below, right? They haven't done that. This bill provided that if somebody receives a conviction for DUI or driving with a measurable controlled substance as a misdemeanor, if the defendant was already prior on APMP supervision for an unrelated case, that misdemeanor court may order APMP to be the supervising entity for that DUI misdemeanor case. All right? There's a lot of good benefits to that, right? We don't need multiple probation agencies overseeing, multiple fees that defendants are maybe having to pay around. There was a lot that did this. And so when this bill passed, it looked very good, except for the bill that Will just talked about also passed. And there's a statement in House Bill 260 that says, in a new statute, a court may not order the department to supervise the probation of an individual who is convicted of a Class B or C misdemeanor or an infraction. So we have two competing statutes that passed this year, one saying a court may order it, one saying a court may not order it. So basically we've got this issue with Spider-Man saying it's you, it's me, it's you, it's me, which one is it? What you're going to see is that APMP is not going to supervise any of these, and the legislature just simply needs to figure out which policy they want to adopt, because they've now adopted in the same legislative session two completely opposite policies that contradict each other. And so I've explained a bill to you to explain to you that probably nothing's going to change, and they're going to just have to address what's going to happen with that.
Okay, Senate Bill 117, Human Smuggling Amendments. This does a couple things that will be beneficial to us in the fight against human trafficking. First of all, the base offense under 765308, the severity of that will move from a third-degree felony to a second-degree felony. The aggravated offense under 765310 will then move from a second-degree felony to a first-degree felony. And then this bill also amends one of the aggravating factors. So if there are 10 or more victims smuggled, that would equal an aggravated human smuggling offense, regardless of whether or not the victims were smuggled in a single episode. So take a look at that if you handle the human smuggling offenses, because we've got more teeth, a stronger grip on some of the penalties for this, and trying to continue to fight the good fight.
The content from this slide came from a great presentation that Dan Burton from the Attorney General's office put together. It's in-depth, and Senate Bill 98, Asset Forfeiture Amendments, is a perfect example of a compromise bill where several stakeholders come together and the result is a mess. The impetus behind this legislation was the Savely case. And the Savely case asked the question of, when does the state court get jurisdiction over seized assets? And essentially what Savely decided, or the Supreme Court decided in Savely, is that when the receipt is provided by law enforcement to the person whose assets were seized, that's when state jurisdiction vests. The problem is, under the statute, the law enforcement agency didn't immediately have to provide that receipt. And so, in theory, there could have been a window of time after the seizure, but before the receipt was provided, when jurisdiction was unknown. What this bill does, or the original impetus for the bill, is to make it clear that from the moment of seizure, the state court has jurisdiction. And what that means is, if you actually have an innocent owner, it's a fabled creature like a unicorn, but if you actually have an innocent owner whose assets were seized, they can go to the state court and seek redress. They don't have to wait for a receipt in order to pursue their rights. The other things this bill does are interesting. And I say interesting because the goal of certain special interest groups, like Libertas, is to eliminate civil asset forfeiture. But the result of this legislation and previous legislation is there will be more civil asset forfeiture. Pop quiz. What's the statute of limitations for filing an infraction? Rob? 1 year. The statute of limitations for filing an asset forfeiture matter is 75 days. So while you have up to a year to file an infraction in a criminal case, you only have 75 days to initiate an asset forfeiture proceeding. What that does, that tighter timeline, is it builds in an incentive for prosecutor and law enforcement agencies to pursue civil asset forfeiture, because if they don't pursue that, their time might run out before they're done screening the longer cases. And certainly what we know from asset forfeiture is that most of them are drug cases, so they're not infraction cases. So your statute of limitation is a matter of years. But the way the statute is constructed, there is an incentive to start these cases as civil asset forfeiture. The way that they tried to address that is they have opened up the ability to transfer. So you can start a case as a civil forfeiture case and transfer it to a criminal case if it's not already resolved and you've filed a criminal case. We have also removed what was previously a brick wall to prevent transfers to the federal system. The burden of proof for asset forfeiture in the federal system is substantially lower. The timelines in the federal system are substantially longer. The system is a lot more lenient towards law enforcement and a lot more strict against the individual whose assets were seized in the federal system. Previously, though, under Utah law, There was a brick wall that said you can only transfer an asset forfeiture from the state system to the federal system if the state judge finds that the federal judge will provide all the protections offered under state law. And I don't know how much experience you have in federal court, but state courts can't bind federal courts to follow the state restrictions. And so that operated fundamentally as a roadblock that prevented federal transfers. That is not going to be the place anymore starting next week. Starting next week, if you had a case that was already initiated or an investigation that had already been initiated before the asset forfeiture that was federal, you can transfer the case federally. So there are still limitations on what can transfer federally, but that brick wall now has a gate in it. And there are more opportunities to transfer a case that really should be federal from the state system to the federal system. One more point of note. Under current law, a law enforcement agency or prosecutor agency can keep up to 20% of the seized assets to help recoup some of the costs of the entire endeavor. Under this legislation, any agency that either gets a grant from CCJJ or keeps that 20% reimbursement has to have at least one employee who is certified by the state. And the certification process will be provided through Utah Prosecution Council and through Post. So if your agency intends to keep any portion of seized assets or apply for a grant from assets that have been seized, then your agency has to have at least one employee that has been certified under the program that does not as yet exist. But we're going to get on that. We'll get on that right away.
House Bill 26 is involving the 24/7 program. Now, the 24/7 program is a sobriety program that started, I believe, in the state of South Dakota. And it's not to combat necessarily keep people from driving impaired once they have convictions. It's to keep people sober. So it's much more intensive than just having like an interlock device on. There's a lot of research and study that's gone into this. Several states have implemented it. And it is, in my opinion, the best tool that we have to keep people sober and still in the community and actively participating with their jobs and things like that. Several years ago, the legislature started a pilot program with the 24/7 program in Utah. And it started out in the AG's office and realized that that wasn't the place for it, so it got moved over to the Department of Public Safety. And Weber County has been operating the last couple years this 24/7 pilot program for the state. They've seen some really good results there. You can talk to the people in Ogden City and Weber County. There's been some really good results there. So this year, one of our own ran the bill to expand the 24/7 pilot program to statewide. And that's the major thing that this bill does. Now, what I want to tell you is by the legislature passing that and saying the 24/7 program is now statewide does not mean that you have a 24/7 program in your county. These require quite a bit of work. A lot of buy-in from your county attorney, if you have city attorneys, from your sheriff, from the courts. There's going to be a lot of work to get this off the ground and running, but I suggest you get going on it because it is an invaluable tool. In fact, some of the research out of South Dakota, they're using it outside of DUI cases and other types of cases where alcohol is a major contributor, like domestic violence cases, and they're seeing much less recidivism for the people that are participating in these programs, okay? It's intensive. There's a lot required of the defendant to be able to enter into this, to be able to keep their driver license and other benefits, staying out of jail, other things that the 24/7 program affords them, but it keeps them sober. And if you're sober, you're not driving impaired. And for a lot of people, if you're sober, you're not beating your significant other either. And so there's some really good things there. Another thing that this bill does is it allows for some reinstatement if people are actively participating in drug courts. So there are certain offenses, drug offenses, that suspend a driver license. If somebody's actively participating in drug court, there are provisions where they can get their license reinstated as a provision of successfully completing drug court. If they're not successful, obviously that would change. The last thing this bill did, and it got kind of combined with another bill eventually, is it addresses the per se administrative suspension of a driver license when somebody's arrested for DUI. So when somebody gets arrested for DUI, their driver license is automatically suspended. It's an administrative suspension that doesn't have anything to do with what we do in the criminal process. Of course, you can go to a DL hearing and go and maybe get your license back that way. This provision allows somebody to self-elect to become an interlock restricted driver to obtain their driver license back after arrest. All right? So let me tell you what that means. It only applies for first-time offenders. So if it's a second or subsequent offense, they can't afford themselves with this. They have to complete a risk assessment, and the risk assessment that's likely to be used, they're still working the details out of that, but there's an impaired driving assessment that NHTSA has sponsored that is being used around the country that they're probably going to use for this. And you have to be found to be a low-risk offender. So they don't want high-risk offenders being able to afford themselves with this. They must install an interlock on any car they own or drive. So if you own 3 vehicles in your name, you're going to have to put interlock on 3 vehicles, even if you're only driving one of them. And so to be able to do that, you have to leave the interlock on for the full 120-day suspension. If somebody decides this is too expensive, screw it, I'm not doing the interlock anymore, then that administrative suspension is going to kick back in once the interlocks are removed. The last thing I want to point out for us, which is more appropriate for us, is this does not apply to the conviction that happens after, or the suspension that happens after a DUI conviction. So once we've gone through the process, if somebody is convicted of DUI, they already become an interlock restricted driver. Our rules already have that in place. And so they can't self-elect to become something they're already going to become and get the driver license suspension reduced. One thing that we're probably going to see as a result of this is you're going to see a lot of people coming in, a lot of defense attorneys coming in and begging you for an impaired driving plea deal, right? Because they're going to come in and they're going to say, look, my client went and became an interlock restricted driver. He got his license back. If he pleads to the DUI, he's going to lose his license again, going to lose his job. I can't plead to a DUI. It's got to be an impaired driver. That's probably going to be the practical effect of how this impacts us. And so be aware of it. Of course, your case, your plea offer, you can decide what you want to do there, but that's what I suspect we're going to see a lot of for people who elect to do this.
Okay, House Bill 255. This bill is basically a clarification, some additions, some cleanup of House Bill 403. As you remember last year, we had 403 that consolidated a lot of the orders of protection language into one chapter so that we had more uniformity, and it made some changes to the lengths of different orders of protection. Once the rubber hit the road on that, there were some additional changes that needed to be made. So we've got 3 different parts in this bill that addresses it. It's 47 pages long. I'm not going to talk all 47 pages of it. So please, if you are dealing with juvenile court issues, protective order issues, or jail release agreement issues, this is a bill you are going to want to take a look at. But in brief, let me highlight some of the points, starting with protective order provisions. This bill adds that violation of a criminal protective order is a second-degree felony if that violation occurred in the furtherance of bigamy. So it adds an additional crime and severity for that as a second-degree felony. It also adds that the conviction of disorderly conduct, we know that that is not a conviction for purposes of federal law or the federal firearms limitation, but now it also adds adjudication. So it's adjudication or conviction is not a conviction or is not a qualifier for the federal statute or the Federal Firearms Act. And then it adds as a domestic violence offense adjudication, again, in addition to what we previously had as a conviction. That can be used as grounds for limiting contact in our sentencing protective orders. So previously, the sentencing protective orders limitations were tied more directly and limited more directly to convictions. Now an adjudication would be sufficient grounds to address that need if it's needed to protect your survivor. Now let's talk about jail release agreements. I'm sure most of you, if not all of you, have had questions from your law enforcement in the past year about how the jail release agreement part of the statute was put into play. The language talked about a jail release agreement could be issued if someone was arrested, whether or not they were booked into jail, which inferred citation, but we didn't clearly state it. Legally, we get to the same endpoint. But there were so many questions, and then there became disparity throughout the state as to who was issuing under what circumstances, that this was something that we went back in to make sure that it was clear to all so that we would be having those jail release agreements issued even if they were cited. So If you've got a perpetrator of the following offenses: domestic violence, sexual offenses, offenses against child or vulnerable adult, and now also sexual battery. If you have violation of those and there is an arrest, or your officer is citing and releasing for whatever the reason is, best practice is to book them into jail, especially on domestic violence and sex offenses. But if they are releasing them for whatever reason, they can and should be issuing a jail release agreement under those circumstances. So we issue a jail release agreement, and then a victim wants to get a waiver. So last year, or during the course of the year, we had victims trying to get waivers at police departments, jail, courts, which it provided that they could do that. But there was a lot of confusion as to, well, that's not our job, that's their job. Some of our survivors were getting the runaround. The court was trying to accommodate, and so they would provide waiver paperwork, but then they didn't have a file. A charge hadn't been filed yet. So it sort of went into this miscellaneous file where someone actively was trying to connect it to the right case as far as a waiver. But you can imagine humanity and error. I guarantee there were circumstances where that information didn't get connected to where it needed to be. So if someone wants to waive it, an adult victim, they can now go to, and it says in the statute, they can go to the law enforcement agency who arrested or cited and released, or they can go to the jail. So if they were booked into the jail, then they can go there, and the jail should be taking those folks and providing the waiver for them, even if they were arrested by another agency. So basically, a survivor has two places to go if their perpetrator was booked. And then thirdly, if and when charges are filed, then a survivor could go to the court and get a waiver. The court will no longer be taking waivers if there is not a charge filed yet, because they want to make sure that if they're taking a waiver, that it does get connected where it needs to be. And so they won't be taking those unless it has been filed. Unless they have a case, there will not be a waiver taken by the courts. They'll be referred back either to the jail or to law enforcement. Then another part of this that clarifies, what about those circumstances where we have jail release agreements issued and say, my perpetrator's in jail, I have children, I want to waive that jail release agreement for myself and my children because I want my perpetrator to come home for whatever my reasoning is, whatever I'm balancing my dynamics, fear factor, whatever that is, I feel like it's best for our family that he comes home. So I want to waive it for myself and my children. Again, we had disparity throughout the state and different agencies. Some would allow that, some would not. And so we had some discussion. There was some pushback from defense. Initially, this language included that they could not, without the approval of the court, waive on behalf of a minor. That we wanted to have that extra fail-safe in there that the court would be aware of it. Well, COVID, of course, lack of accessibility to the courts. One argument was that, what's the point of doing a jail release agreement or charging on behalf of a minor if basically, they lose value because they could just be, they won't be waived. There was all kinds of arguments on it. But what we did come to as an agreement was they could not waive if these one or more of these three things were part of that case. And so this is going to be important to convey to your law enforcement officers, because as they're handling these cases, the DV, the sex offenses, the vulnerable child abuse cases, and the sexual battery, we need to know some of this information. So one of that involves whether or not there was bodily injury suffered by the minor. Okay, so if one of the children was injured during the process of the underlying domestic violence event, then they cannot waive, the parent or guardian cannot waive on behalf of that minor. If a child, one of the children, tried to call for emergency aid, 911, or actually did call for emergency aid, then they cannot waive it. The reason why we had that discussion was because, in my opinion, and this is why I argued for it, as we were trying to determine what the heightened risk factors for children were, is that I think that makes them a target, more of a target than a child who is present but doesn't take any action to try and intervene on behalf of the victim. So if a child, and this is where your law enforcement, they're going to have to check with dispatch who called in. Did we have a child call in? Because if that happened, then they need to put that in their notes, in their PC statement, so that a jail release agreement will not be waived by the parent or guardian if that occurs. And then the third one is, if within that window of time between the offense occurring and then the jail release agreement being signed, the waiver, being signed, if sometime during that window there is a disclosure by a minor child of a threat to them of bodily injury, I'm going to come back and get you, especially if they call 911 or one of the other many circumstances that we've seen. Then in that circumstance, again, if that's disclosed, the threat's disclosed, then a waiver cannot be signed without the approval of the court. So those three things, without the approval of the court, a waiver cannot be signed. Hopefully that makes some sense. We wanted, of course, to protect all kids, but we had to focus on some of the higher danger risk factors. The third part, which I'm just going to touch on briefly, this has to do with orders in the juvenile court system. This bill designates the expiration and sets out the expiration periods for a jail release agreement in the juvenile court. It also sets out the expiration for pretrial protective orders in the juvenile court. And it also addresses continuous and sentencing protective orders. Specifically, a continuous protective order may not be issued against a minor unless the juvenile court has transferred that jurisdiction to the district court. And why, you might say, is that happening? Those of you in the juvenile court, you understand why. It's because juvenile court jurisdiction terminates. And so if you have a continuous protective order or a sentencing protective order, but specifically a continuous protective order in this instance, juvenile court terminates their jurisdiction, but what happens to the protection for the victim? So it has to be transferred to a district court. And Michael Drexel was a big part of input on that, trying to set the parameters and trying to have the courts accommodate providing that protection for survivors involving juvenile court issues. So again, take a look at this bill. If you have questions, let me know. I'm happy to answer those. Specific to juvenile court ones, I would refer you to Michael Drexel if you have questions on that. But regardless, let us know if you have any questions on it.
There is a little-known law of physics which states if an international news outlet criticizes something your office did, a Utah legislator will open a bill file about it. Last year, Utah Black Lives Matter protesters engaged in some protests that devolved into riotous conduct under Utah statute. Our office filed first-degree felony charges using a gang enhancement against some of those individuals. And that received widespread criticism from several news outlets, including The Guardian, which is a daily in Great Britain. The Guardian did not mention the other times that our office had used the gang enhancement on first-degree felony to get to first-degree felonies last year. If you have a chance at lunch to go to our city library, you'll go past where the police car was lit on fire last summer. That was charged as a first-degree felony by our office. If you get hungry and want to go to the food court at City Creek, you may want to stop by Morgan Jewelers, where during the same day as the riots, a group of people broke in and stole over $500,000 of jewelry, and that was charged as a first-degree felony. With the passage of Senate Bill 51, group and gang enhancements, none of those, the red paint, the burning police car, or the break-in to Morgan Jewelers, will qualify for gang enhancements. There are three fundamental changes to gang enhancements that start next week. Number one, the minimum number of participants increases from 3 to 4. Number two, in the past, there was a requirement that a person be physically present or participate as a party. That or is flipping to an and. So they have to be physically present and participate as a party in order for the group or gang enhancement to apply. And number three, there is a limitation to the qualification of what offenses qualify for group or gang enhancements. If you've got a criminal mischief or a graffiti case, you can only gang enhance that up to a third-degree felony. So if you're already at a third-degree felony, there's no such thing as a group or a gang enhancement. Generally speaking, when it comes to all property crimes, with some exceptions, you cap out at a second-degree felony. And it's a little misleading because there's a pattern of unlawful activity that's mentioned, and there's burglary of a dwelling that's mentioned in that section. But those are already second-degree felonies. And so enhancing those with a group or gang enhancement, in theory you can, but you would enhance it from a second-degree felony to a second-degree felony. So functionally speaking, there is no longer an enhancement for those crimes. But any other property crime caps out at about a second-degree felony. When it comes to person crimes, or 76.5 crimes, you will still be able to group or gang enhance it up to a first-degree felony. But that is what will be taking effect when it comes to group enhancements starting next week.
Senate Bill 108 addresses the issue of subsequent offenses and convictions and enhancement periods with possession of drug crimes. Basically, the message here now is chronology matters. So under the old statute, I guess as the statute is written for the next few days, if I got a drug possession charge in January and another in, say, April and another in July, if I pled guilty to the July and April matters, that January offense could have been enhanced because there's 2 prior convictions. Now the legislature is saying that these have to be subsequent offenses. So if somebody pled guilty under that hypothetical to the July and the April offenses, that January offense would no longer be enhanceable because it's not a subsequent offense. It happened prior to. So when we talk about maybe what we might see down the road, we might see defense attorneys be really, really interested in pleading the most recent case and getting that resolved, right? Because then you won't be able to take the prior cases and enhance them. So just a heads up on that. You may be looking at criminal histories and seeing arrest records. It might be worth reaching out to other jurisdictions and having conversations with other jurisdictions and figuring out how you're going to resolve cases. You might not care. And so if you don't, then don't reach out to other jurisdictions, I guess. Ryan, you had a question? Yes, this is to the drug possession enhancements that we just added, what was it, last year or 2 years ago when they dropped that to 7 years? So it used to be an indefinite enhanceability period, right? And it was either last year or the year before we shortened that to 7 years. So yeah, it's just those drug possession. No.
I figured we all needed a cute picture right about now. Okay, we're going to talk about intimate image distribution. There's been some changes. There were several bills that went through the legislature this year. A lot of them directly related to some of the circumstances surrounding the Lauren McCluskey case. This is one of them, but this bill does a few different things. First of all, it adds to that list of prohibited acts the knowingly duplication or copying of an intimate image. So we've now got an additional qualifying act that has been added there. It also modifies the knowledge element. So previously we had to prove that a defendant knew that the depicted individual had not given consent to the actor to distribute the image. And now what we have to show is that the actor has not received consent from the depicted individual to distribute the intimate image. So there's a shift there. Be aware of that. It also created a new subpart in this that criminalizes distribution of intimate images received in the context of a criminal action. This is what, one of the looks back at Lauren McCluskey. So this criminalization, this new crime, applies to prosecution, defense, law enforcement, courts, anyone, all equally responsible and liable should they violate this section by displaying. So they're prohibited from displaying, duplicating, copying, or otherwise sharing an intimate image obtained in the course of a criminal action, unless. So there are 3 exceptions to this. If they are doing that solely for the purpose of prosecuting, defending, investigating, or adjudicating the case, then it's okay. If they are doing that and the person in the intimate image has given written consent, then they're okay. And if they are doing that and the image was not created by or provided to the actor under circumstances in which the depicted individual has a reasonable expectation of privacy and that can be articulated, then they're okay. But other than that, they're very tight. And I imagine, and my experience would be that for the most part, we have been, and our law enforcement have been complying with this. Perhaps there are some agencies or areas or individuals that have gone a little lax or have kind of wandered from what best practices were. But this now makes it a criminal offense. So again, we're going to want our officers to know and our office colleagues to know that when we have these kinds of intimate images in our cases, we have a responsibility and we have to protect them from being displayed, copied, and so forth.
I wasn't planning on this, but I feel like this is shifting into a science lesson. After my law of physics that I just shared with you, I now need to communicate another fundamental rule, and that is that correlation does not mean causation. Last year, COVID hit. Last year, Utah passed bail reform. Bail reform did not cause COVID. Okay? Just want to be clear about that. And I want to be clear about that because a lot of the criticisms of House Bill 206, when there was a drill down, 206 was last year's bail reform bill, when there was a drill down as to what caused this concern, a lot of it was about COVID. For example, our jail populations across the state really dropped quite substantially. Salt Lake County has a jail dashboard, and you can look at the population of the jail, and you can see in March the population dipped, and it hasn't gotten back to where it was. But bail reform didn't take effect until several months after that, in October. So the plummeting jail population was not caused by bail reform. In spite of that, many people were concerned about many things related to bail reform. And so what was marketed in 220 as a pause or a reset is not taking us back to where we were, but putting us in a third area of what bail is in Utah. But it's not an area where we will stay. There will be a fourth area, because when Governor Cox signed House Bill 220, he said this is a terrible bill, but there are people who are going to work to make things better. And so we will call a special session, and we will pass a new and improved law at some point in the future. Starting this week, the working group has begun to meet, and I am confident that at some point before the next legislative session in 2022, there will be another iteration of bail reform in Utah. But let me explain a little bit about the universe that we're going to be going into starting next week. The statutory presumption that someone who's not a public safety risk or a flight risk be released on their recognizance has been repealed from the statute. The statutory requirement that when imposing a financial condition, you should consider the individual's ability to pay is being repealed from the statute. The motion process by which you can ask for pretrial detention of someone who is a public safety risk is being repealed from the statute. The definition of a pretrial status order is being repealed from statute, but the term pretrial status order is not being repealed from the statute. The rules and the court rules on how to address pretrial conditions are not being repealed from statute. So while you have a statute that will no longer say the least restrictive means that will reasonably ensure public safety and appearance, you will still have a rule that requires the least restrictive means. While you have a statute that will talk about the fine or the bail schedule, which has been transformed into a pretty little matrix that caps out at about $5,000, will still cap out at about $5,000. So you are entering into an era where the statute and the rules aren't saying the same thing, and it's not clear that either is going to change in the short-term future to align. So in this time of ambiguity, when the baby has been thrown out with the bathwater, I would encourage you to look at Article 1, Section 8 of Utah's Constitution. Offenses are bailable with 3 exceptions. Number 1, if you've got a capital offense where there's substantial evidence of that capital offense, that is not a bailable offense. Number 2 is the felony on felony. So when you've got substantial evidence of someone who's committed a felony while they were out on another felony, that is not a bailable offense. And number 3, it says any other offense identified by the legislature when there's substantial evidence of that offense and clear and convincing evidence of either a danger or a flight risk. And the state legislature has intervened in that area. Any felony, as long as you've got clear and convincing evidence of danger or flight risk. Domestic violence, when you've got clear and convincing evidence of danger or flight risk. And DUIs, when death or serious bodily injury results, when you've got clear and convincing evidence of danger or flight risk. There's problems with that. The first-degree presumption of detention, the presumption that someone's dangerous when they've been charged with first-degree felony, that's also been repealed by 220. If you're prosecuting sex crimes, you know that many of those sexual offenders officially don't have a criminal history, realistically had not been caught before in many cases. That's going to be a hard situation for you to show that releasing them would be a danger. But that is the area where you can ask for detention. If you think, oh, don't worry, before 206 last year, we were just asking for $500,000 bail and really hoping that they couldn't post it and then they'd be in and we wouldn't even have to argue about this pretrial detention. Well, the case law suggests that when you put an unaffordable amount of bail in as a term of release, you're actually denying release, and they are entitled to the same protections and due process rights. So you can't do that shortcut. And even if you try to do that shortcut, remember that the judges still have the matrix that caps out at a max of about $5,000. So good night and good luck when it comes to bail.
I wasn't involved in many of the bail discussions this session, and I'm really glad I wasn't. There was a lot. House Bill 239, online impersonation prohibition. This bill really stems from a pretty scary incident when you think about it. Last year, after the George Floyd incident and some of the events of the summer that really brought a lot of issues to the forefront in the media, there was a post by, and I don't know all the details here, so I'm not going to act like I'm an expert in exactly what happened. But basically, the essential of this was the wife of a police officer posted on social media some pretty bad stuff. Because of what the wife posted on social media, the officer was put on administrative leave, spent a significant amount of time on administrative leave, and what they found out was it wasn't the wife of the police officer that posted this information. It was somebody who was impersonating the wife of the police officer and fake posted under a fake account. So when they discovered this, they went into law, they looked at it, and they realized they couldn't charge this person with anything. While as horrific as it was that this happened and basically almost ruined somebody's life, there was nothing they can charge them with. So there is a new offense of online impersonation. To just kind of summarize this pretty quickly, it's not just that I create a fake account with Ryan Robinson's name and picture on it, right? That's not the violation of the law. The violation of the law is creating a fake account with someone else's persona without their permission and posting things that you want others to believe are coming from that person, but you also have to have an intent to harm, defraud, intimidate, or threaten another individual. So there is an intent component here that goes along with that. But realize that we now have some provisions where this type of a scenario, the person could be charged, whereas we didn't used to have that. Another thing that this bill did is it added a new subsection to the electronic communication harassment statute, which is similar in the topic. It's when the communication references the personal identifying information of another. It's sent without the individual's consent and with the intent to cause the recipient to believe that that individual is sending these things, and again with intent to cause physical, emotional, economic damage or defraud the individual. So we have another provision in the electronic communication harassment. One thing I want to point out that was interesting about this is it created a new enhancement for the electronic communication harassment statute. Much of our electronic communication cases come from DV, right? I don't know that I've ever charged an electronic communication case that wasn't domestic violence related. I probably have, but few and far between. With the DV, we always had an enhancement anyways. Without a DV tag, electronic communication harassment is now an enhanceable crime. First offense is a Class B misdemeanor. Second, or any subsequent offense, is a Class A misdemeanor, and that's for all electronic communication harassment. For the other online impersonation, that offense is a Class A misdemeanor. Any subsequent offense would be a third-degree felony.
HB 147. So this again goes back to 76.5B 203. This makes an additional change and amends the statute, specifically that proving actual emotional distress or harm is not an element if. So if the individual depicted in the image was a victim of a crime, then you do not have to prove the emotional distress or harm. If the image was provided to law enforcement as part of the investigation or prosecution of a crime committed against that victim, if the image was distributed without a legitimate law enforcement investigative purpose by someone with access to the intimate image due to their association with the investigation or prosecution, and it's an and, not an or, and if the victim is incapacitated or deceased. So we've had a couple changes to that intimate image statute you want to take a look at.
That's so many ands, I'm surprised they didn't say, and if the victim was named Lauren McCluskey. This is actually a picture that I looked up, riot, and the first one that showed up was Salt Lake City last year. And that is the fire. It has been put out, but if you go to the library, that's where it was, where that event occurred, or right behind the library area. So this bill, riot amendments, does a few things. Some are very defense friendly, and some are very law and order or punishment friendly. The things that are more pro-defendant is it changes the definition of riot to remove tumultuous conduct. So tumultuous conduct does not qualify as riot anymore. Another change is that the felony enhancement used to be applicable in riot whenever bodily injury resulted. Now it has to be a substantial or serious bodily injury. And those seem like reasonable changes. The two changes that are, we'll say, less defendant friendly are, first, when someone is booked into the jail, they have to stay in jail until they appear in front of a judge. And the second is that if someone commits felony riot, they can be held without bail if there's clear and convincing evidence that they would pose a flight risk. You may be thinking, but well, the last bill you talked about, you said any felony was like that, and this is only about felony riot. Well, what does that do? The answer is nothing, but it's based on a story that actually started in Minnesota and repeated across the country. Every time a riot occurred last year, you heard, oh, most of the people committing this riot aren't from here. They're outside agitators who have come in and are causing these riots and then leaving, never to be seen again. That was first mentioned in Minneapolis by the mayor and governor. It was actually rescinded. They admitted that's not actually accurate that day. But by the time they had said that, Speaker Nancy Pelosi and President President Trump, both had tweeted about how outside agitators were involved. And throughout all summer, whenever riots occurred anywhere in the country, you heard this refrain of, oh, it's mostly outsiders. Well, I can tell you the riots in Salt Lake, by and large, were committed by residents of the Salt Lake area. And for most of the country, that's what occurred. But if you end up in that off-chance situation where a bunch of outside entities come into your jurisdiction and commit a riot and are at a risk of flight, if they're not held, you can detain them without bail pending trial.
House Bill 20 is DUI sentencing amendments. This is a bill that creates what I'm going to colloquially call today an extreme DUI. All right, the statute doesn't call it that, but that's what we're going to call it today to kind of articulate what we're doing here. So there's three ways in which we can get now what we are now calling an extreme DUI here. If there is admissible evidence of any of the following, all right? So that's a key component to it. There has to be admissible evidence that somebody is at a 0.16 or higher BAC. So just strictly a DUI, alcohol-related DUI. If that person has a BAC of 0.16 or higher, that now fits this enhanced sentencing penalty provision of an extreme DUI. The second way is if they have two or 0.05 or higher BAC and any controlled substance in addition to that on board. All right? That now qualifies as an extreme DUI. And then the last one is any two unprescribed or unrecommended controlled substances. So two or more, I guess, would be the case. So that's the three ways that we get an extreme DUI. All right? Now what you need to know what happens once we have an extreme DUI is we have enhanced mandatory jail sentences that go along with these now. Okay, so if you have a first DUI, and it is an extreme DUI, rather than getting 48 hours of community service or 2 days in jail, that person has to spend 5 days in jail or 2 days in jail plus 30 days of home confinement with alcohol monitoring. All right, so the community service provision on an extreme DUI is gone. And then that minimum goes to either 5 days or 2 days plus 30 days home confinement. For a second DUI in 10 years, it does not matter what the first DUI was. The first DUI does not have to be an extreme DUI. It matters what the current DUI is. If it fits any one of those three definitions of an extreme DUI, second and 10, instead of getting 10 days in jail, that now goes to 20 days in jail. Or 10 days in jail plus 60 days home confinement with alcohol monitoring. On this second DUI, there is also a provision that allows a court to impose a 10-day jail sentence, plus ordering the individual to obtain substance abuse treatment if the court finds that the substance abuse treatment is more likely to reduce recidivism and help public safety. But the prosecutor has to agree to that. Okay, everybody has to be in agreement on that to have that other aspect on the second DUI. If it is a third DUI or a felony DUI, any felony DUI, I guess, under the circumstances, and again, it doesn't matter what the first two were. They could just be your regular non-extreme DUIs. We're only talking about if that third is a felony or extreme DUI, it's 120 days in jail rather than the 62 and a half, plus 120 days of home confinement with alcohol monitoring. So these are basically the idea here is these extreme DUIs are more dangerous than just an 05 DUI, right? And so they should be treated differently. We've got a lot of talk recently about fair practices and not treating everybody the same. Well, that also when you're more dangerous, you should be handled more strictly than if you're less dangerous, and that's the idea here. Also, in addition to the extended jail penalties, all extreme DUIs are mandated supervised probation now. Okay, the 1-6 or higher was already supervised probation under the statute, but these others were not, and so they're added in and they are supervised probation. If you have an extreme DUI, all right, the legislature has now prevented you from offering an impaired driver plea deal for an extreme DUI. And I've gotten some kickback on people I've talked to about this, mostly from defense attorneys actually. Why is the legislature intruding on a prosecutor's discretion? And I remind everybody that the impaired driving plea deal was created by the legislature. That's not something that we just have the authority as prosecutors to offer, right? 41-6A-502 is our DUI statute. 41-6A-502.5 is the impaired driving statute. We can't charge that offense. We can only enter into that as a plea agreement for a plea resolution. So if the legislature gives us the opportunity to have this plea resolution, it's perfectly in their purview to tell us how we can use it. They could even repeal it and not even allow us to use it at all, right? It was a legislatively created plea offer, and so the legislature is absolutely in their it's their prerogative to tell us how we can use it. Another thing that this bill did outside of the extreme DUI is DUI. We can't offer a plea in abeyance on a DUI, right? And in practice, you actually can't offer a plea in abeyance on an impaired driving either. There's actually no proper statutory legal way to get a plea in abeyance on an impaired driving, because if you do it the way the statute lines it out, the person pleads guilty to DUI and the conviction is entered to impaired driving. That's how the statute reads. And so there's actually no way to do a plea in abeyance to impaired driving because you pled guilty to DUI and the conviction is entered on impaired driving. But this bill did clarify that you can't give a plea in abeyance on impaired driving anyways, because we do see those. There's also no plea in abeyance available on driving with a measurable controlled substance anymore, or our DUI metabolite. You cannot offer a plea in abeyance going forward. And then also on our new criminal refusal that passed last year, when somebody refuses a blood draw after a warrant's been issued and they've received that admonition, there's no plea in abeyance available for that offense either. Another thing this bill did is the Class A misdemeanor for DUI with a child in the vehicle, right? If you have a child in a vehicle, that Class B becomes a Class A. It now allows for multiple counts of DUI if there's multiple children in the car. And this tracks our serious bodily injury or death cases where we can charge multiple counts. So if somebody's DUI and they have 4 children in their car, we can charge 4 Class A misdemeanor DUI offenses if we choose. The last thing this bill did is, and it was a lot of the parties at the table were really concerned about this, is we didn't want to de-incentivize the 24/7 program. As I talked about the 24/7 program being a great program, we want to incentivize people to get into that 24/7 program. So language in this bill basically makes this cooperate with the 24/7 program, that if somebody is admitted into the 24/7 program, they can avoid some of these extended jail stays so long as they successfully complete the 24/7 program. If they don't, if they get kicked out of the 24/7, violate whatever, then whatever jail time they have left, they would have to go and serve that extra jail time. Now, for repeat offenders, they are still going to have to spend some time in jail. The federal government actually requires for a repeat offense that they spend a minimum of 5 days in jail. If they don't, we risk losing our federal funding that comes along in our highway funds. So if it's a repeat offense, extreme DUI, they're still going to have to do a minimum of 5 days in jail before they can get out and enter the 24/7 program to avail themselves of this. So, yeah, that's that bill. So be aware of that new sentencing structure on the extreme DUIs and the restrictions that go along with that.
Okay, a lot of good DUI results from that bill. I'm going to give you some not so good self-defense results. This bill evolved, and there was a big push from, firearms attorneys, stand your ground laws in other states, a couple other states. And so there was a big push on this. This basically was going to go through one way or another. A lot of prosecutors and other associated agencies, really rallied, reached out. Representative Lisenby was great as far as listening to us and trying to make concessions. It really came down to just 2 different perspectives. We just had 2 different perspectives on it, but the discussion was there, and I just want to invite and encourage you, when you see these bills, when we get into this legislative part of the year, to reach out, to talk to people. It makes a huge difference. And even if it's a bill like this, where it was coming through in one form or another, we went from something terrible to something not as terrible. But either way, this is going to create some additional obstacles for you as prosecutors. So with that sad intro, what this does is it creates a pretrial justification hearing process. So what that means is a defendant can file a motion under Rule 12 of the Utah Rules of Criminal Procedure, and that will then require the court to hear evidence on and to make a determination as to whether or not that defendant was justified in their use of or threat of use of force. At the hearing, the defendant has the burden of making a prima facie case or claim of that justification, and then the burden shifts to you as a prosecutor to prove by clear and convincing evidence that that use or threatened use of force was not justified. Then the court makes a determination as a matter of fact and law, and if the court determines that it was justified, then the court will dismiss this charge with prejudice. Okay, so end, done deal. Dismiss it with prejudice, but we do get to appeal it. So if the court determines the defendant's actions were not justified, then the defendant can come back at trial and raise that justification argument at trial. We cannot, as prosecutors, we cannot reference to or raise our comments on it, would not be admissible. We cannot reference to the fact that the court previously found that it wasn't justified. That now becomes a matter that the jury will deliberate on and make a determination on. There are some exceptions to this, and these were exceptions that were, hard fought for and part of some long discussions. So this would not be applicable if the use or threat of force is against a law enforcement officer who's identified himself as an officer and is acting within the scope and responsibilities of his official duty. This would not apply if the case is an infraction Class B or Class B. So all you Justice Court prosecutors can heave a huge sigh of relief when you anticipate, and as I was thinking of how many times a defendant can get another, bite out of the apple. So if it's an infraction class B or class C misdemeanor offense, it does not apply. And this one was very hard fought for, and we almost didn't get it. But the case, if it's filed as a domestic violence offense, then it is not applicable. And again, we were most concerned about this forcing a victim or us as prosecutors to have to convey and put the burden on a victim to participate in this hearing process. It would be very hard for us to meet our burden without their involvement. But we were able to get that accepted. As a result of this new process, House Joint Resolution 7 had to make a change to the rules of criminal procedure. And so they've changed the timing on that. So take a look at that. As a practical tip on this, we know Utah has one of the broadest definitions of cohabitant. So back to that domestic violence exception. If you are in the Class A DV or felony DV prosecuting arena, you may want to look at your cases, and as a matter of discretion and judicial economy and balancing of a lot of factors, consider filing as a domestic violence offense, and then later on consider what your negotiated outcome would be. I can't tell you, you know what, just go out there and file them all DV. You know, if it fits in that, you just file it as DV so that they can't raise this flag and make that justification claim. I don't think that would necessarily be using our discretion the way that we should. But I do think that we should take a step back, be looking at that definition with a broader scope, talk within your offices, develop a policy. You may want to be filing more of these as domestic violence and then seeing the case through to whatever your outcome would result in being. So it's something to consider given those exceptions.
We are now.
I don't believe so, but I don't know for sure. So I will check on that. My understanding, my belief was that it is moving forward. Charging decisions moving forward was the application, but I'm not going to bet a Diet Coke on that until I take a closer look at it. So good question, Ryan. I'll figure that out. Okay. So we will double check, but that likely would be the outcome. But I'll look at that and get you an answer by the end of the afternoon, confirm one way or the other, so you know moving forward. Good question. Hadn't thought of that.
I can tell you in Florida, that issue did come up. Florida has a similar statute. They had an earlier version of the statute, and they amended the standards within the statute. And the case law in Florida said, if you already had one of these hearings, you don't get another hearing just because the standards changed. I think the problem that you'd have with the pending case is because this hearing didn't exist before, nobody's had them before. So if it's short of a verdict or a plea, I think there's a real risk that you may have to have these hearings. In fact, Michael Clara testified at every committee hearing about this bill in support of it because of a case that our office is currently prosecuting him for, and we have every expectation that he will be requesting one of these hearings. All right.
Just made my bad news worse news.
Oh, sorry. In that vein, one of my favorite apps is TikTok this year. I just downloaded it during the pandemic, and I know China owns it, blah, blah, blah. They own us all anyway. But one of my people that I follow on TikTok every day tells me, okay, unclench your jaw. Are you being hydrated? Are you drinking enough water? I want you all to take a deep breath in with me and a deep breath out, okay? So breathe in all the positive energy. Breathe out all the negativity. And then he goes on with some expletives about, own this day, make it yours, with some swear words in there. So the good news is this bill is a good thing. So this is a taking a good breath, let out the bad. House Bill 62, post-certification amendments. Weird thing about Brady, Giglio obligations of prosecutors is we have to turn over evidence about impeachment. But when it comes to impeachment evidence about an officer, we can only turn that over to the defense if the officer or the officer's agency gives it to us. And so there's a built-in contradiction there. We have to give something that we don't have without the cooperation of someone who it may hurt. Under this bill, if an officer has been found to engage in dishonest or deceitful or biased or prejudicial conduct, either by a court or by the agency, then post can discipline the officer for that conduct. And the reason that that's a benefit for us as prosecutors is that when that's reported to post, and when post decides whether to impose discipline or not, we suddenly have a record outside of the officer's cooperation or outside of the agency. So under this legislation, if an agency or a court has found an officer engaged in deceitful, dishonest, biased, or prejudicial conduct, there will now be a new source, and that's post-discipline records that we can use to meet our obligations under Brady and Giglio.
House Bill 47, DUI revisions. This was also called by the sponsor Sarah's Law, named after Sarah Fry, a teenager who was tragically in a crash where she lost her legs and several of her friends were injured. If you watch the news, the offender in that case was just sentenced this week. He's going to spend several years in prison for it. But as a result of that, it kind of brought up a goal here. Here's what the goal of this statute was. And my slide here might be slightly over dramatic, but we use over dramatic to illustrate points all the time, right? But the intent of this bill was really good. It was, one, to provide a way for DUI offenders who cause serious bodily injury or death an opportunity to remain in jail, right, pending their case. The second was define substantial evidence. Will talked about earlier House Bill 220 and the constitutional provision that we have to show substantial evidence of the offense to be able to qualify for that. And but there's no definition of substantial evidence. And so this, the way this bill was drafted was going to provide a statutory definition of what substantial evidence means, which is always helpful, right? And then the last thing was to make clear that witnesses and witness testimony are not required at these detention hearings that we were going to inevitably have. That the information would not have to be through witness testimony and cross-examination and other things that way. This bill stayed that way and in that form all the way through the House, went through Senate committees, stayed that way, went through the first two readings on the Senate floor that way, and then on the third Senate reading calendar, some floor amendments came in and really changed things pretty significantly when it comes to this. So one thing that happened is that definition of substantial evidence was taken out. So we don't have a statutory definition of substantial evidence. We're stuck with arguing about what that means. But what it did do is it says that the right to bail statute, and Will mentioned this earlier, allows for DUI, driving with a measurable controlled substance offenders when they substantially or cause substantial serious injury or kill people. All right? That if the court finds that there's substantial evidence to support the charge and finds by clear and convincing evidence the danger would pose a substantial danger to the community if released, they can be held without bail. One of the things it also did is it created a rebuttable presumption that if somebody does this, that they're a substantial risk to the community. So we do have that in there. We don't have the substantial evidence rule anymore, or definition anymore. But what happened when it came to the witness testimony at detention hearings could end up being problematic. This bill passed, and it said that if the prosecutor could make showing that it would cause an undue burden on the victim, then victims would not have to come in and testify. HB 220 further amended that, and it said would not unnecessarily intrude on the rights of the victim or place an undue burden on the victim. So we do have some protections, and we're going to have to make a showing that it would intrude on the rights of the victim or have an undue burden on a victim, which in victim cases, having them come in very shortly after the crime and have to testify and those things, we can probably show that, in many cases at least. The problem is that only applies to victims. So other non-victim testimony, so witnesses, police officers, others, are very likely going to have to come in and testify at these hearings. And so be aware that the way that this bill passed is not how it was intended. And sometimes that happens with legislation, right, Will? Will made a comment yesterday, and I don't want to butcher it too bad, but sometimes having a terrible idea just become a bad idea is considered a win. And you don't win them all. And this is probably one of those where we didn't win them all, except for when you parade a victim of a horrific offense like this before the legislature, and then things go different. It's hard to then ask the governor to veto that bill, right? And so it is what it is, and we may be able to get some things done as we move forward with that, but there will be some problematic things with it, but we do still have some more that we didn't have before.
Okay, just real quickly, this bill addresses some notice requirements when it comes to obtaining a warrant. If it's an open investigation, law enforcement, a warrant to access electronic information and data. So if it's an open investigation, law enforcement now have 90 days to notify the owner of that information or data instead of 14. If it's a case that has been already concluded, the investigation, then the owner has to be notified within 3 days of the conclusion of the investigation. And also law enforcement can still ask the court to grant an extension for 30 days. However, the court will no longer be granting, and they're no longer able to grant in 60-day increments. So we're going to get smaller, pieces of extension depending on your judge, whether or not they're willing to extend more than once, but we won't be getting those 60-day windows. Also, if you have a fugitive from justice and there's a warrant issued and this fugitive has committed a violent felony, then the court can suspend those notice provisions, meaning basically to toll it, to stop the clock from ticking until the owner of that data information has been apprehended. And then within 14 days, they have to be notified of the warrant for the information and data that they owned. And then finally, the bill extends the statutory warrant exceptions to now include electronic information or data in our investigative subpoenas. So there's a change there that you need to be aware of.
The saying a juvenile should do adult time for an adult crime is pithy, it's catchy, but it assumes that there is time that attaches to the adult crime. The Boggs brothers killed Officer Corey Brotherson when they were juveniles, and they were adjudicated in juvenile court and sent to a secure facility up north. One of the brothers turned 18, and the other brother was still under 18 when they committed more offenses while they were in secure facility. The prosecutors at that point decided, you know what, we're going to file charges against these people as adults. One was an adult, and the other was a juvenile, but because they were in a secure facility, they were able to be charged as adults. The consequence of that was that it cut off the juvenile court's jurisdiction. It ended the sentence that they were serving for killing Officer Brotherson. And when they were convicted of their adult crimes, it was, I think, 60, 90 days that they were in custody, and then they were free to go. So the consequence, certainly unintended, was that by charging these juveniles as adults, these people who had killed an officer ended up out in the public sooner than they would have otherwise. House Bill 67 is meant to close the Boggs brothers' loophole, if you will, which indicates that just because a juvenile is convicted in adult court does not terminate the juvenile court sentencing. The adult court has to indicate whether it's consecutive or concurrent to the juvenile sentence, but that juvenile sentence will continue, and only after that will the adult sentence initiate, unless it was concurrent. That's House Bill 67.
House Bill 291 deals with residential picketing. Basically what this is we're not going to allow the picketing at the governor's house anymore, picketing at Dr. Dunn's house because we don't like masks anymore. It defines residential picketing and has some parameters there, creates a new Class B misdemeanor for that. A couple things that it doesn't apply to is you are free to picket at your own residence all you want. You can target your own residence and picket all you want. You can also picket at places that are common for doing business, like county councils, commissions, the legislature, other places like that. And then also general picketing that proceeds through neighborhoods and continues on is not met under this definition of new definition of residential picketing. So you still could technically picket past the governor's house. You just couldn't stop there. okay, as long as it keeps proceeding through and doing as it was. Another factor of this, it also makes another Class B misdemeanor to post other people's address and say, hey, go picket at this. So not only the picketing, but the inciting of the picketing, the residential picketing, is also a Class B misdemeanor.
I'm not sure I'm a fan of that. You can picket your own house, especially if you have teenagers. That could be bad. Okay, House Bill 216. So we have not talked about, but I'm sure you've all heard about House Bill 60, and that's the bill that legalized the carrying of a concealed firearm for adults over the age of 21 without them having the necessity of getting a concealed carry permit. That, because of HB 60 passing, it actually made a lot of HB 216 irrelevant. However, in consultation with Legislative Research and General Counsel, they did point out there are still some things that we need to be aware of with this bill. So I'm just going to touch quickly on those. First of all, under federal law, a person could still need a concealed carry permit in order to carry a firearm in a school zone, because there is a federal law limiting the carrying of a firearm in a school zone. Some may also want to get this permit for reciprocity with other states, and they're not eligible for that reciprocity unless they have a permit here in Utah. In addition, this bill provides a path for persons with provisional. So those are those that are 18 to 20. They have a provisional concealed carry permit. It provides a pathway for them that once they turn 21, then that becomes a valid concealed carry permit as an adult. HB 60, because it only applies to 21 and older as far as not having to carry, this bill clarifies where provisional permits, or 18 to 20-year-olds, where they can carry firearms on certain school premises. And then it further clarifies that people applying for a renewal permit do not need to retake the firearms training. There is anticipation that there will be those that will still go and get concealed carry permits. In fact, my son this week just went and went through a class to get his. And the hope is that people will still do that so that they are aware of the laws and they can protect themselves and conduct themselves lawfully with these concealed carry weapons, firearms. So what this talks about is that renewal. They don't have to retake the firearms training in order to renew. It will just continue on and renew after that if that's what they're opting for it to do. There's some additional information there I'll just refer you to as far as the overlap between HB 60 and HB 216, where that begins and ends. So take a look at that, the analysis that was shared with us through the Legislative Research and General Counsel. This may or may not be the analysis that is adopted by the courts as we go down the road, but take a look at that and be aware of that as well.
When it comes to law enforcement interrogating juveniles, a parent, a guardian, or a friendly adult has to be present. And by juvenile, I mean anyone under 18. There are two exceptions under this law. Number one, if the parent, guardian, or friendly adult was actually there to waive the right for them to be there, with the juvenile waiving as well. Or number two, after law enforcement has spent at least an hour trying to get the parent, guardian, or friendly adult to be present. So the safest approach going forward, if law enforcement is interrogating a juvenile, parent, guardian, or friendly adult needs to be present.
I call House Bill 142 the James Swink Act. As one of our own county attorneys, General Good Guy, he's also an avid cyclist, so this is the most important bill of the legislative session for James. Basically, you're riding a bike, you don't have to stop at stop signs anymore, under certain circumstances. We got some other cyclists around, okay? This doesn't apply to red lights, doesn't apply to red road crossings, things like that, but if you come to a stop sign, you can yield as long as you slow to a safe speed. You yield to other traffic and pedestrians in the intersection or adjoining crosswalks, and you can do it safely. You are now able to yield at stop signs and not stop.
Okay, so that actually reminds me, when I was about 20, I moved to Lethbridge, which was a large city in southern Alberta, and I could get lost in a brown paper bag. I have absolutely no sense of direction. And I was trying to bike. I didn't have a car yet. I was trying to bike back home to the home where I was staying with my friend, and I was lost. And so I was paying more attention to where the heck was I than I was a red light. And it was out on a perimeter of the city, and I rode through a red light as I'm trying to figure out where the heck am I. And it would so be that even though there were no other cars around, there happened to be a police car behind me. So he pulls me over, and I remember thinking, you know, as a 20-year-old, you can get pulled over on a bike for running a red light? Anyways, when I told him where I was headed, he told me, he goes, you are going in the wrong direction. And he threw my bike in the back of his car, and he took me home, but made me think of that. Okay, post-conviction, Pcra, Remedies Act. Just real quickly, basically this bill has just gone in and corrected the standard. Previously, the petitioner had to show that the defect was prejudicial. That is, that there's a reasonable likelihood of a more favorable outcome should the error not have happened. But the constitutional standards require an easier prejudice standard. So this bill just went in, brought the statute in line with the constitutional standard. It also corrected the PCR language and now permits relief based on that constitutional standard. It includes, additionally, a wider latitude in appointing pro bono attorneys in these cases. The belief is, and we probably can agree, there are lots of times when I'd much rather deal with an attorney than a defendant. Not always, however. Then this bill also clarifies that no procedural bar, so there's no default or statute of limitations preventing the granting of post-conviction DNA testing or determination of factual innocence. So that's removed. So one practice tip that came and that is in there, I just want to draw your attention to, even though there's a wider opportunity and to provide these pro bono attorneys or to allow for the retention of a pro bono attorney, they're not entitled to it. Specifically, under this statute, they're not entitled to it. And the recommendation is that we should be resisting any arguments that they're entitled to it, that they're entitled to paid counsel like our public defenders, or that they're entitled to any other undue post-conviction judgments on the basis of ineffective post-conviction representation. So when you do get these cases and they come forward, you know, be aware that we are trying to accommodate, but there is a limit to that, and we need to stand our ground and resist that entitlement because it doesn't exist.
Another one of my favorite time waste apps over the last year has been Reface, and it's where it's like a copy and paste for faces. And so this is the Three Stooges, but with Reface, I was able to attach these Three Stooges faces onto those Three Stooges. And that's funny, it's cute, it's fine. And Marlesse, I'm sorry about your hair.
That's a bad hair day.
But this technology can become a lot more problematic if, say, instead of showing a picture of the Three Stooges, I were to show a pornographic video and then put Ryan Robinson's face on top of it. House Bill 193 addresses that kind of a scenario where you take an intimate image, something that would be qualifying as an explicit image, and you attach someone else's face on top of it. Originally, this would have been in the revenge porn statute, but the revenge porn is more about a consensual exchange of images that then gets out of that consensual exchange. This is about a situation where you take something obscene and slap somebody else's face on top of it. And the penalties range from a Class A misdemeanor to a second-degree felony, depending on whether there's a history and whether the victim involved is a child. It's a great new tool for great new technology.
House Bill 166, livestock amendments. This adds livestock guardian dogs to the definition of livestock. So if anybody spent any time out in the mountains, anytime during the summer or the fall, you've probably seen herds of sheep with these Great Pyrenees dogs, other types of dogs. If somebody kills one of these dogs now, it's considered wanton destruction of livestock. It also changes the penalty structure for the value. Now, we're pretty comfortable with under $500 being a Class B misdemeanor, $500 to $1,500, Class A misdemeanor, $1,500 to $5,000, third-degree felony, above $5,000 being a second-degree felony, right? That translates across the board in many of our offenses, and that's how wanton destruction of livestock has always been. That is now changed, all right? So you're going to want to be aware of this. The Class B misdemeanor was reduced to $250, so if it's less than $250 for this offense, it's a Class B misdemeanor. $250 to $750 is a Class A misdemeanor. $750 all the way up to $5,000 is the third-degree felony, and then over $5,000 is a second-degree felony again. We've got one more minute.
So real quickly on this, if you are a rural prosecutor or a prosecutor in an area where the health department does not do your HIV testing, specifically involving incarcerated individuals, take a look at this bill. We've provided the language to close the gap between using an alternate site, which now we say, go ahead and use an alternate site as decided by that detention facility, jail, correction facility. And then also that information will be released to the prosecutor, and then the prosecutor can release it to the victim. Because we ran into a problem in southern Utah where they didn't have an alternate, or the health department didn't do their testing. They used an alternate site, and then they ran into what were HIPAA concerns. So they've tried to fix that. So take a look at that.
This is Dr. Andrew Baker. He is the Hennepin County Medical Examiner, and I'm not going to tell you anything else about this bill because our time is up. If you have any questions, feel free to contact us. Thank you for your time. Enjoy your lunch. It's at lunch on your own today. And 1 hour?
What time we come back, Bob?
2 o'clock. Come back at 2 for a civil update.